Hello guys, and welcome to another episode of my lecture. On today's episode of my lecture, I will be talking about the presumption of regularity under Cama 2020. So basically, we'll be talking about the extent at which such presumption is applicable under the Cama 2020. To what extent can we say that the presumption of regularity is applicable under the Cama? And in this particular lecture, we'll be talking about the presumption of regularity that the memo and the articles of a company have been complied with. That's what we'll be talking about in this lecture. But before I begin this lecture, I want you to, throughout the course of we talking about presumption of regularity, for you to understand perfectly how this presumption of regularity works. I want you to imagine that you are standing outside a very big mansion. Do you understand? You've never entered this mansion before. You are currently in front of a mansion. You are standing there and you are looking into it. Now, I want that mansion to represent a company. Do you understand that? So I want you to listen as I read this provision and how they relate to the analogy of you and the mansion. It is very, very important to understanding the presumption of regularity under the Cama. So let us go to the first presumption. And what does the Cama say? According to section 93 of Cama, it provides that a person dealing with a company or with someone deriving title under the company is entitled to make the following assumptions, and the company and those deriving titles under it shall be stopped from denying their truths that A. The company's memorandum and articles have been complied with, which means that here an outsider, here a third party, here you in that mansion analogy who sees the company here being the mansion, has certain powers under the memorandum and articles. Now, when you got to the front door of that particular big mansion, somebody gave you the paper. That paper is to tell you how this big mansion operates. When you saw the paper, you saw that this big mansion has A, B, C. Now, according to this rule, that is the presumption of regularity under section 93A, you see that paper that you saw representing the articles of memo of the company, you see the ABC. There is a presumption on you that that ABC you saw in the memo and articles are binding on the company and that the company have complied with ABC. Do you understand? In that mansion, there is a presumption that the ABC that you saw on the book, that book being a manual as to how the mansion or the company operates, there is a presumption that the ABC has been carried out. Do you understand that? Now, I want us to then go to section 44.3 of Cama, which says that no act of the company, conveyancy, or transfer of property to or by the company shall be invalid by reason of the fact that such act, conveyancy, or transfer was not done or made for the furtherance of the authorized business of the company, or that the company was otherwise exceeding its powers. What that basically means is that you see the ABC that has been written, those ones, they are general ABC. But when it comes to the business of the company to be stated under 27(1)(c), the business and object clause of the company, or the powers of the company, the business and the powers being two different things, but both of them being encapsulated in section 44.3. When it comes to the business or when it comes to the power of a company, where you are dealing with that particular mansion, where you do something that has not been authorized by the memo or by the articles, that particular transaction, that particular dealing with the company will not be invalid merely because it wasn't authorized by the articles or by the memo. Do you understand that? That is the reason that there is no constructive notice on the third party. Because if there were constructive notice, it means that that subject matter that you are entering the company for has not been authorized by the memo or by the articles, it would definitely then mean that there is constructive notice on you and the transaction is therefore invalid. But now that the doctrine of constructive notice has been abolished under the Cama, it means that there is no notice on you. In fact, it means you don't need to read the memorandum and articles of association. What matters is the fact that there has been a transaction entered between you and this particular company. Whether another transaction has been authorized under section 27(1)(c) in the memorandum or has been authorized by the articles is not a relevant fact. What is relevant is whether or not the company has entered the transaction. Because by virtue of 44(3), that transaction will not be invalid merely because it was not part of the stated business, which means that a third party need not read the memo and articles. The third party can enter any dealing with the company. Do you understand that? Also, if you look at section 89B of Cama, which says that a company can't escape liability for acts done in connection with a business which wasn't part of the business authorized by the company's memo. Do not forget that section 89B refers to the three organs, the liability of the three organs when they act. That is the board of directors, the members in general meeting, and the managing director. Where those three organs act and their act is such that wasn't authorized by the memo or by the articles, it would mean that they would not escape liability merely because it wasn't authorized. So therefore, while section 93A of Cama entitles an outsider, you the third party, section 93A entitles you to presume that ABC, as has been written in the manual of the mansion. Therefore, everything that has been written in the memorandum and articles of association has been complied with by the company. And also, section 44(3) and section 89B of Cama renders a company liable for acts done which weren't part of business authorized by memo. A company isn't thus allowed to use the excuse that a certain business it did wasn't part of the authorized business in order to escape liability. So in this case, it's straightforward. There is a presumption of regularity on the part of third parties, on the part of outsiders, to presume that the memo and the articles have been complied with. To further buttress it, where a company enters a transaction with a third party, the company will not escape liability or say that that transaction is invalid merely because the memo does not authorize it. There is a presumption that when you were entering that act, it is such that you are complying with the memo. Therefore, you cannot then enter the transaction and say that it is invalid because your memo doesn't authorize it or your articles doesn't authorize it. There is a presumption that your articles and your memo authorized it. Do you understand? Section 44(3) as well as section 89B buttresses section 93A to tell us that there is a presumption that memos and articles have been complied with. Now we are going to the next presumption, which I'll be discussing in my next class. See you in my next class.